In 3, 2, 1, go ahead.
Good afternoon. Welcome to Thurston County Board of County Commissioners Superior Court update. Thursday, February 4th. That's not right. March 4th, 2021. It's 1:01 p.m. My name is Ty Menser, Chair of the Board. We have Commissioner Gary Edwards, Vice Chair of the Board. Through the Zoom platform, we have Commissioner Carolina Mejia in the boardroom, County Manager Amiro Chavez, presiding judge of our Superior Court, Judge Eric Price, and our Superior Court Administrator, Pamela Hartman-Beyer. And this is our monthly check-in, and I know a lot of things have happened since the last month, so I'm sure we'll have plenty of topics for discussion, but it is open. So usually we just start with Judge Price, kind of opening salvo for what you think we ought to know, or you'd like to tell the board, to talk to the board about.
Well, thanks, and hello to all the commissioners. And yeah, it's there's a lot going on. I'm questioning how much to talk about initially. I think there's the one thing that we talked about a month ago that I think we anticipated, which was the resumption of jury trials. Let me start there. We did, a month ago, we were still under a suspension of our jury trials for criminal matters with an expectation of March 1 to resume with jury trials. We had a number of matters that were confirmed for a Monday, this past Monday, and to include several that were scheduled to go over in our new trial space. And I don't know what the phrase would be, best laid plans. But essentially there was some, we had about 9 or 10 cases that had confirmed for trial, all in custody, several resolved, which was of course good news. And we never know whether they would have resolved had they not been actually set for trial with resumption of trial. So that's good. But there was also, and I don't want to get into too many details, but 2 of the attorneys that had multiple of the trials became unavailable to do those trials. So that necessitated some continuances on several of the high priority cases. It was just one of those things that was, health related issues. So we ended up we ended up having 1 case that was ready to go up until some evidentiary issue happened that caused a delay in that trial as well. And that one's currently set for this coming Monday. So the long and short of it is, although we were all dressed up and ready to go, we ended up not having a jury trial actually commence this week. We do have 2 at this point set for Monday, and we have multiple ones that have confirmed for the 15th. So we're anxious to see what happens there. I know there's a motion to continue, and one of them will be heard this afternoon. But we'll see. But at this point, we are otherwise ready, up and ready to go with jury trials. The other issue I definitely wanted to get to before I forgot, I think Romero had specifically asked Judge Schaller about the Safe Babies Court and wanted an update on that. She was unable to make the elected officials meeting to provide an update, and she has provided to me a written update, which I intend to essentially read verbatim. She's sort of the expert on the status of the Safe Babies Court, so I do expect to read that. But before I get to that, is there any questions about the jury trial update?
Commissioner Edwards, just pipe in if you have a question on things. I'm not going to be as formal as usual. Does anybody have questions?
Okay. I don't have a question per se about the jury trials, but Judge, are you going to cover some of this new Supreme Court ruling on the drug issues?
Well, I thought that was probably where the bulk of the concern and conversation would go. So I do intend to talk about that. That's a statewide issue of concern right now. So I'll talk about that. I can do that now if you'd like, or I was going to get to the Safe Babies thing.
No, if you've got a plan, stick to your plan. I was just wanting to make sure that I heard something about that. Thank you.
Plan may be overstating what I have, but
Did you get, so one question is, did you get far enough with this evidentiary issue that came up in the last case? Did you get far enough that you had to call jurors in and assemble them and whatnot, or did it happen before that and you called them off?
Pam, I think they were here. Is that true? Yes. In fact, not only were they here, but there was some dialogue with them about their experience of coming in and assembling. Pam, do you have more
That's what
information
I'm curious about.
Yeah.
Yeah, Liz went through the entire orientation process with the jury offsite at Chandler Court. She knew after she had finished that the case had been continued, and so she kind of inquired from the citizens that came in what their experience was like and if they had any suggestions. And everyone seemed to be really happy with the experience. They felt safe in the space, and we got only good feedback. I can ask her if there's any specifics other than that to share with you, but she said she thought it went really well and she got really good feedback from our public.
Great, that's what I'm curious about. If there was a chance to sort of do a practice run, and see, make some tweaks and get some feedback. So that's great. Commissioner Mejia, anything?
I do not have anything. I guess I'll just add a comment. If you haven't gone through the jury service with Liz, maybe it's an experience I invite all elected officials to do. It's definitely really eye-opening, and they have a great jury administrator over at Superior Court who definitely has an upbeat personality for those jurors coming in early.
Great. Okay, safe babies. I don't know anything about this, so I'm curious.
Yeah, let me just tag on to and thank Commissioner Mejia for those comments. We are really pleased with the job that our jury administrator does, and just like Commissioner Mejia said, she is a specialist in dealing with grumpy people at 7 o'clock in the morning who don't want to be there and have them leaving with a smile. I mean, she is fabulous. It's a talent that she has, and we're really pleased with that. Also. She shared with me the same thing. She specifically mentioned that they were pleased, that the jurors she spoke with were pleased with Chandler Court's ease of parking and with the flow within the space, flow within the building. So those are two, particularly the flow. It's not something we had been able to dry run before. So we're pleased that thus far the comments have been really positive. And I think she also did, Pam, correct me if I'm wrong, but she did not. She told me that there was not a lot of safety concern that she heard from the jurors who appeared. And that, I suppose, is not terribly shocking because the ones who had discussed a lot of significant safety concerns didn't, they had been rescheduled. But nevertheless, I think there was some reason for optimism that we're not going to have difficulty in securing juries going forward here in this time period where we're, there's still obviously COVID concerns, but resuming trials. So we were pleased with that news.
I think, go ahead.
Well, I saw her with hand waving.
Yeah, I had a question back here. I was just wondering how many jurors were called this week.
That was going to be my input. So we called one panel in the morning with 26 people. To make sure that we could have a panel of 20, and 24 ended up showing up. So those are pretty good numbers. That's what we normally get or better turnout, and we felt really comfortable with that moving forward.
Yeah, I think Liz sort of anecdotally thought that maybe people are happy to get out of the house.
Probably.
So if there's not more on that, I'm happy then to move into the Safe Babies court. Pam, did you want to provide just a super high level summary of or sort of introduction to what the Safe Babies court is, how it came about, and then I can go ahead and read Judge Schaller's update?
Yeah, the Safe Babies Court came about. It's a pilot program in Washington State. We're one of 3 counties that have been selected. It's us, Spokane, and Kitsap. The program, I believe, already exists in Pierce County. I could be wrong about that location. And we were selected through AOC. They received a grant that Judge Price will talk about in a second. But it's basically to give more specific early intervention services to families that have children age newborn to 3 in the dependency action. So it's kind of a more intense family recovery court.
Yeah, so it's still the concept is the sort of the treatment court concept of having both supportive services as well as judicial oversight, intervention, and interaction that provides both carrot and stick with trying to get behavior modifications and services to these really high risk, participants in the dependency situation. So that's what it is. And here's the update. And I apologize for reading it, but I think I know Judge Schaller put a lot of work into this piece, so I'd like to just respect that by reading it kind of verbatim. The Thurston County Safe Babies Court has been working with 0 to 3, which is a provider, correct, Pam?
The national organization provider, yes.
Yeah. The Center for Children and Youth Justice and the Washington Administrative Office of the Courts to finalize the contracts, sub-award agreements, and data license agreements applicable to launching the project. Stakeholder partners were selected for both a site-based learning collaborative team, which is a team of individuals participating in in-depth trainings and workshops, and site leadership team, which is responsible for making day-to-day decisions. The first meetings for both teams were held in January and February, respectively. The site leadership team will be actively working with 0 to 3, which is again the national provider, on the tasks and processes necessary to launch the Safe Baby Court. Currently, the site leadership team is examining such issues as eligibility, meeting space, and frequency of court hearings. The Safe Baby Court Community Coordinator is a person by the name of Laura Vogel, and she started in her position on December 15th in 2020. She is engaged in an intensive cohort community coordinator learning academy and individual support calls, state team meetings, and other learning opportunities designed to guide Thurston County in the development and implementation of the Safe Baby Court model. The community coordinator, which is Ms. Vogel, is actively working to identify and engage with community partners who work in some capacity with the families that the Safe Baby Court will serve. Numerous meetings and presentations have been scheduled over the next few months with the potential Thurston County project partners. We have developed a logo for the program, and I don't know if you can see that. It's kind of a nice, cool logo. And the coordinator is with Administrative Office of the Courts well, that's not a complete sentence, so I'm not going to read that. All right. An exciting recent event is that our program secured and this is a term of art, OLET Smart Sock baby monitor system that records a baby's oxygen level and heart rate in real time. And this technology that we now have access to will have numerous practical applications in Safe Baby Courts, such as teaching, co-regulation with parents and infants. Judge Schaller and Ms. Vogel will continue to work together in building a strong team that can launch what we hope will be a sustainable program. So that's the written piece. Pam, do you have anything to add to it?
No, the only thing I'll add is we have this grant through, I believe it's the end of October. We're hopeful that the state will secure additional funding moving forward after that point. I know there was legislation before the House. And Ms. Vogel, just for everyone's information, was previously our family recovery court coordinator and transitioned into this role because she's excited to build this new program and really believes in it. I will tell you the other thing is we've had fantastic collaboration with stakeholders. We have someone from Nurse Family Partnership practitioners. We have attorneys. We have community stakeholders, and it's I don't know everyone by name right now, but it's been great to work with everyone.
So it sounds like the grant is really to get it kind of set in place, and then you got to kind of go from there. Any other questions from the board on this?
No, sir.
Yeah. And Pam, correct me if I'm wrong, but part of the part of that setup is, I mean, we're really sort of building the mousetrap from the start. I mean, it's not like there's a very common model that we just kind of import. We're actually sort of building the brick and mortar of it. So that's sort of, and doing it the right way means involving so many people and having a lot of these meetings. So I think the process is just being very thoughtful and deliberate right now, but it does mean it takes some time.
Your Honor, thank you. And thank you to Judge Schaller for the follow-up on the request.
Yeah, happy to do it. So that was all I had apart from what is the hot topic and State v. Blake, which came down last Thursday regarding the possession, the law regarding possession of a controlled substance. And at this point, I can tell you that, well, just in a nutshell, the court found it the statute, the court meaning the Supreme Court, found the possession statute to be unconstitutional. And it's got a lot of ramifications because it's not, when something's unconstitutional, generally speaking, is retroactive as well as prospectively enforced. So all of the possession charges and consequences of those possession charges are kind of up in the air now. And I think we've been meeting with the stakeholders. We've had meetings with our criminal administration meeting, which occurred just yesterday. We had updates from both Prosecutor Thunheim as well as Director O'Connor about the efforts that both public defense and the prosecution is making to sort of triage the problem. We had an update from Chief Tama regarding some of the concerns that corrections may have with the potential for mass transports of people for resentencing. But I think, and we can talk through kind of where we see the issues, but we're really, I think, from a court's perspective, we're pretty impressed with our partners in taking a very active role in trying to understand what this means with respect to people, real people in the jail right now, or cases that are pending right now. I know that I personally have signed a number of dismissals and warrant quashes on cases that the prosecutor has determined are based solely on possession charges. And so that's happened almost immediately. But the consequences of this decision are far-reaching. I know that the county's got certainly concerns with legal financial obligations. I think it will mean tens of thousands of resentencings for a variety of reasons, not just those folks who are in custody on possession, but those folks who a possession charge has affected their offender score and then therefore changed their range for sentences that they're now in custody on. We'll have a lot of requests for vacations, clearly, from past convictions. We've I think at this point, in terms of practical changes for what it means for the court, we are going to have to, at some point, address how to deal with the volume of the resentencings and potential other issues that will come up, but it's a little premature at this point. I know that all of the associations are working on this. AOC is working on it. Department of Corrections at a state level is working on it. Prosecution of associations and defense associations to try to grapple with how to systematically go through dealing with the consequences of it. But that's, I'm more than happy to talk with you all about what this may mean, but I think that's the context of the conversation is what it may mean. I think what it means is something that is hard to tell at this point.
I don't know if Washington's had this experience, but, there's got to be a way not to reinvent the wheel in terms of how you go about in an orderly way dealing with this. When I was in Alaska as a public defender, we had the Blakely case. And the Blakely case said that aggravating factors that could enhance someone's sentence were akin to elements and had to be submitted to a jury and proved beyond a reasonable doubt, could not just be decided on a lesser standard of evidence if it could increase the maximum range by which, and that's basically how aggravating factors worked under Alaska sentencing. So it wasn't quite as broad in tens and thousands, but somebody had to systematically go through everyone's sentence and figure out, would this apply, create a body of cases, dole them back out to the public defenders. I got assigned a number of them. Briefs were created. You know, we created classes of briefs, and you had Blakely 1, Blakely 2, Blakely 3, and you throw it into a bucket, and then you had kind of a brief that you could tweak and manufacture, and we just kind of plowed through them. It was time consuming and laborious, but what I'm saying is that even if Washington hasn't had something like this drop, I know other states have, and we could sort of consult with their judiciary or their prosecuting attorneys, you know, maybe to see if there's a way to deal with this in the best way possible. It's really when you start thinking about all the implications, I hadn't thought about it right off the bat, all these implications. I mean, drug offenses are they're all about, like, they're victimless crimes that are all about search and, you know, the way the drug is found. So all these search issues come up, right? Like, okay, it was an illegal drug. So the probable cause for the search was something that that shouldn't have been a crime, and it led to evidence of another crime. And that's a whole other bundle of issues that, you know, would have to be parsed through, as well as all the offender scores and what you say. So yeah, it's pretty incredible. Go ahead, Commissioner Mejia.
Yeah, so I have a question in regards to drug court and how it's going to affect it or restructure it for the future.
Yeah, well, that's a really good question, and there is an awful lot of concern about not only drug court but also the diversion programs. That, you know, my observation has been a simple possession is not something, absent some other reason, that a lot of folks, particularly in 2020, have been sitting in jail on. So my understanding is there was a total of 2 individuals that were released from jail because of the decision, our jail, who were pending trial. And that number doesn't surprise me, because with COVID, you know, a lot of the drug offenses were not a reason to have, you know, financial restrictions or to hold people. But what was being done with those cases was getting them into drug court and getting them into diversion programs, and having those cases evaporate. I talked briefly with our drug court judge, Judge Skinder. He didn't know, but he suspects that most of the folks in drug court have things other than simple possessions, which means that they're potentially going to still have a reason to stay in drug court. But obviously the concern is, if someone who is otherwise doing well in treatment or otherwise doing well in housing or you know, getting that support that both drug court and diversionary programs provide, no longer has a criminal case that supports those interventions, you know, there's some consequence to that. And so I don't think we know yet what the census consequence to drug court will be. But I know that there's concern about it. There already was some concern about trying to make sure that we kept the census where it needs to be, and at least in our drug court and DUI courts. And what it means for veterans court and mental health court, you'll have to ask district court about that, but I'm sure they have similar concerns about what this decision will mean for those programs. Pam, do you have any additional information regarding drug court?
No, I do know that there's a preliminary number of 11 participants, but I'm not sure how many of those 11 also have other charges. So it's much smaller than other counties, I guess, in number of participants, but I think they're trying to collect data everywhere.
Yeah, and back to your comments, Commissioner Menzer, I think there is a lot of work being done, and in terms of stacks of files and people going through records, and a lot of that work's being done at the prosecutor level and the public defense level, and those are the, you know, Director O'Connor and Prosecutor Chunheim would be far better sources to help you understand exactly what's going on there. At this level, I don't expect a lot of contested anything right now. It's going to be agreed presentations that the prosecutor has made a decision that, these charges need to be dropped, this case needs to be vacated or whatnot. The challenge for the court's going to be in the resentencings. And that's where my guess is that we're going to see thousands of inmates who are at DOC, in prison right now, who are there on incorrect ranges because, a possession charge is going to drop out. And the other thing that gets complicated is washouts, right? So you have some washout prevention from a drug offense. If that goes away, what does that do to ranges? That's going to be a lot of heavy lifting by folks on the state level. And then the question is, how do you resentence them? And those I could see impacting the court in a meaningful way if you're going to have argued sentencing for thousands of people. And typically sentencing would be an in-person hearing. And I know there's discussions that are happening at the state level about, well, can we do them remotely? Because the last thing you want to do, especially in a pandemic, is to have Department of Corrections, launching thousands of inmates from their correctional facilities back to superior courts in the 39 different counties for a contested resentencing within a different range. So that's where I see this going in terms of the impact on court time and court dockets. It's just too early right now to know exactly what that's going to look like.
Pam, you said 11. We have 11. What did you mean? 11 out
There
of
are-
how many
there
in our
are-
drug court that have a possession charge?
Yeah, there are 11 participants that have a possession charge, but I'm not sure how many of those 11 also have another charge connected to their drug court.
And how many total? 11 out of how many?
Our program goes up to 64. I believe right now our census is like 40, low 40s. What I have is that it's about 27% of our total census right now.
Okay.
And I think if I were to guess why that census is low following 2020 is a lot of these offenses have not been, I know the prosecutors, and we've talked about this before, sitting on a stack of referrals that have not been actually charged in 2020 because of the desire not to have, the court system inundated with sort of non-public safety-ish type crimes. And because those types of offenses are not being referred, there hasn't been the driver for a lot of the drug court populace that you might see within 2020. So that's kind of affecting the census. This decision is going to not necessarily help that. But again, prosecutor would be a far better resource as to exactly what percentage of these uncharged referrals that they're dealing with would be simple possessions and what that really means.
Questions from anybody? Ramiro?
Just to add to what Judge Price stated, we had a conversation at the Washington State Association of Counties, the administrators meeting that we have every week. And this was a point of conversation, and it was a consensus of a concern of having to pay back all the financial obligations, the LFOs. And it's not just, as Judge Price stated, is going back in time. And then the conversation stated that that portion of the Constitution was put in place in 1971. So that puts a huge task in terms of trying to pay back all the LFOs. And first of all, I don't know how many. We don't know how many. I mean, it will be extremely difficult to just get to the point. So that was raised as a potential financial impact to counties as a result of this decision.
Okay. No. I guess if there's, I'll share that I sit on the legislative steering committee for Wasak, and we discussed it in terms of what the legislature might do or what we might want the legislature to do. If if they just change the statute to add the knowingly component, it doesn't necessarily change the past. The fact that, so, I mean, the bomb has dropped, even if the quick fix for the future isn't a quick fix for the past, I guess is what I'm trying to say.
Yeah.
And then, you know, there's the whole concept that there was a bill 1499, I think it was, that was trying to reform this statute anyway. So I was kind of hopeful that that would be a kick in the butt to the legislatures to work on that bill and make it better or get it wherever they wanted it to go and pass it. But the Wasak personnel that deals with this, she didn't think that was where it was going. She thought that they were going to try to, you know, not do anything on purpose, which I didn't really understand I mean, I know it's late, a little bit late in the process, but something like this, you'd think that there would be some activity to do something to help a little bit, but we'll see.
Yeah, we received just recently some desperate cry for information to our association, which apparently was precipitated by some conversations with the legislature. And it was unclear to me exactly what was happening there in terms of what the legislature was contemplating, whether it was financial relief or whether it was some other, you know, sort of legislative, not fix for the legal issue, but at least a financial response to the impact that this may very well have.
Mm-hmm.
Speaking of the legislature, I just want to slip this in before I forget, and the commission may know this, but 1167, House Bill 1167, which is the 9th judge legislation that Representative Bateman and Dolan had both sponsored, that and myself, I had testified in front of the Civil Rights and Judiciary Committee and the Appropriations Committee. It did pass the House 97-0 this week. So it got out of the House. We'll see where we go, but we're optimistic about that. You may have already been aware, but just in case you weren't.
No, I hadn't heard that. I hadn't heard anything bad, so I figured no news was good news, but I hadn't heard the vote. 97 House legislators can't be wrong, right?
Yeah, it wasn't unanimous out of appropriations, which was interesting. It was, I think, 33-4 or something. But as I understand, as I watched the deliberation on that, the no votes were related to dissatisfaction with the process, whatever that means, rather than sort of some consternation about the need for the additional position. I would say, in addition to the support of the sponsors, which we're very thrilled that 22nd District representatives both co-sponsored it, but Representative McEwen spoke up strongly in favor of it at the Appropriations Committee, and so we're very pleased that he as well recognizes the need. And I think even, I mean, his 10 seconds, but still, it was a reflection of his understanding of the need of the county to improve the situation. So we were very happy to see that.
Great. Okay. Mr. Edwards, did you get your questions answered on Blake, or do you have anything you want to?
I think it is what it is, and more to come, and we'll just deal with it, it looks like. Yeah.
Commissioner Mejia, anything to ask the court?
No, thank you.
Discuss. I can't think of anything myself. I guess I like to just share information so everybody hears stuff that I hear. So just an interesting conversation I had this past week was with folks from Olympia Municipal Court, and they really would like to move from where they are at the Colocating Justice Center, and they wanted us to know their seriousness so that we could, you know, if there's any synergies going forward, we could work together potentially. Judge Alf, I guess, was really excited about the idea of a therapeutic court center kind of thing. If there was a way to have what they do with their community court aligned with what district court does with veterans court or mental health court or something like that, then he's thinking about, I think, space and like setting up a courtroom in a more therapeutic court. I don't know what that means exactly, but I'm sure he has a vision in his head for what a therapeutic court layout looks like. And then having, more than just Olympia using it. I don't know. They were looking over at 3000 Pacific. They looked downtown at the old firehouse space. They're looking around for appropriate space to grow their program, because right now they're stuck into a building that's aging and et cetera. And they've got their jail, and we all kind of thought, well, they're not going to do anything without the jail coming along with it. But Diane Whaley and Judge All seem to not really be all that concerned about that. I mean, it's possible that Olympia might deal with those problems separately and do something with their court and do something else with their jail. And they don't necessarily have to go together because it just may not be feasible.
Well, it's interesting you bring that up. Judge Alf called me and we had a very brief conversation, and he was just sort of expressing the same thing, that Olympia's desire to sort of explore whether there could be some co-locating of services. What I told him was, absolutely, we will never against to talking about that type of thing. And certainly if there's value to co-locating, that's something we would take very, very seriously. We do have, our population with our, and he was talking about drug court specifically, our drug court does involve a lot of transport, because our folks can be in and out of custody frequently. And so adding yet another offsite location for corrections to have to move with between the ARC and another location is one obstacle. Also, we already have a offsite but co-located drug court program and treatment program, which is a little different than the model of, say, family recovery court or some of their community court type things. So there's definitely some reasons to have further conversations about it. But just in terms of sort of the greater concept of cooperation between tiers and cooperation to try to somehow be more efficient in the delivery of these community-based systems. I mean, we're all in favor of having those conversations. And if we can figure out how to do it in a way that makes both financial and geographic and, sense, we'd be definitely happy to do that. Because there's a lot of, there's some commonality in terms of the struggles that folks in the various tiers are experiencing. And if we can, as opposed to having siloed approaches, if we can be more coordinated, that's a good thing.
Ramiro, maybe you could update the Superior Court on the program manager, because that could be, as a segue, that could be the kind of person that tries to help find those efficiencies, build those partnerships. But I know the board just approved the actual new classification stratum, and Ramiro can say a little more about what the timeline looks like.
Yeah, the board this past Tuesday approved the classification itself, and now we're gonna be working with HR to start advertising that particular position. So I'm hopeful they will get some good qualified candidates. I believe the job description as well as the salary range is appealing, and it's just from what I can see. But I think I'm optimistic to get good qualified candidates, and hopefully we can have somebody here in the next 2 months.
Wow, that's great news.
Yeah, I've had a couple of people ask me who just heard about it kind of offhand, people that were very interested. So I think it's going to garner a lot of interest both locally and hopefully outside as well. Get a good candidate pool. Okay, well, it's 1:40. Does anyone have another final topic? Pam, you usually have a long list for us. You good, or?
I guess I'll just say about Chandler Court, we've been working with AOC, and Robin is aware. We were able to secure 2 months of the lease for Chandler Court through AOC CARES Act funding. They open it up to us every 2 months, and I'm not sure if that's been shared. So we are continuing to try to use resources that are available to us through COVID relief through AOC.
Thank you.
That's good news. Yeah, that's great. Thank you. Commissioners, any last questions for the court?
No, sir.
Okay, thank you so much. We'll be adjourned and,
Thank you.
Thanks for the opportunity, and we will see you next month.
all right, sounds good.